Hello, my name is Michael Tesoro and I've prepared this case note on the recent class action of Williams and Toyota Motor Corporation. Bit of background about myself. I'm a competition and consumer lawyer and I've been running my own practice, Tesoro Legal Consulting, for 13 years. Prior to that, I worked at the HCC for 15 years and I had a variety of roles there, including as direct enforcement. So I'll be seeking to bring my insights as a consumer lawyer to bear on this particular case note. The outline of the presentation, I'll start with the background to the case, then the claims made by the plaintiff's lawyers, outline the decision made by Justice Lee in the case, and finish up with some commentary. Now, the background to the case is that it was alleged that between October 2015 and April 2020, Toyota had released these particular vehicles which had a defect. The number of vehicles impacted by the alleged defect were 264,170, and they're in three particular ranges: the Prado, Fortuner, and HiLux ranges. And these vehicles have been fitted with this diesel combustion engine, which also include a diesel exhaust after treatment system, which was aimed at reducing the level of emissions from the engine. It was called a DPF. And the allegation was that this DPF system was defective as it wasn't designed to function effectively during all reasonable expected conditions of normal operation and use of the vehicle. So effectively, when you drove over a certain speed, the system did not work and caused various problems for the motor vehicles. So there's a summary of the DPF system, and had two core components, which were a filter and a diesel oxidation catalyst. And effectively, the exhaust would go in on the left there and get captured in the DPF, and these diesel particulate matters would be dealt with and stored in that particular area and not released into the environment. Now, the problem was, as I said earlier, that the core defect was the DPF was not designed to function effectively in the Australian market. Effectively, if a driver was to go over 100 kilometres an hour, then the DPF would not operate effectively, which is a pretty standard speed for many people in Australia to travel at, in any country, I guess. And effectively, what occurred was that the DPF system was ineffective in preventing the formation of deposits on a particular surface. And as a result, the surface would bulk up with these various agents and result in a number of problems with the car. For example, excessive white smoke and foul smelling exhaust coming out of the car during the regeneration. Also, the problems would trigger the car's onboard diagnostic system, and that would obviously lead to errors which required the car to be taken to a service centre. So as you can see there, their design defects were mechanical as well as impacting the control logic and software calibrations. So the claims made by the plaintiff was that the relevant vehicles were not of acceptable quality and therefore failed to comply with the statutory guarantees in section 54 of the ACL. And secondly, that the conduct had been misleading and deceptive. And effectively, the plaintiffs alleged that there had been positive misrepresentations made to consumers that breached those provisions, section 18, 29, 1A and 1G, as well as 33 of the Australian Consumer Law. But also there'd been omissions. So Toyota had failed to advise its clients, its customers, of problems with the vehicles of which it was aware. Now, the evidence was pretty well agreed upon before the trial commenced. There were two reports of a referee, first in October and the second in August 2020 and 2021. And this had included all the relevant findings based on the facts about what had occurred. And that resulted in the preparation of not one but two agreed statement of facts. So a first agreed statement of facts and then a supplementary statement of facts for the purposes of Section 191 of the Evidence Act. So you would assume, given the referee reports and the agreed statement of facts, that this case would have been quite routine. However, as the judge commented there at paragraph 14, that's not what transpired. Effectively, there was a large number of contested factual issues raised by Toyota during this hearing, which the judge had assumed had been agreed and locked away as a consequence of both the referee reports and the agreed statement of facts. The first issue was to consider what the level of failure of the vehicles would be, and this was from the referee report, and they're quite stark. The analysis of the referee indicated that 50% of those relevant vehicles will fail after 5 years, and almost 100% would fail after 10 years. So these vehicles and the defect alleged with the DPF system were very significant. And the judge also looked at this argument that Toyota raised that the core defect did not impact upon or interfere with the operation of relevant vehicles, or that the relevant vehicles continued to be suitable for use in all driving conditions. So these submissions put by Toyota to the court, which were in direct contradiction to the evidence which had been agreed earlier. And this was a constant area of frustration for the judge, because he often referred to the fact that Toyota were making submissions to the court which were not supported by the evidence, which were inconsistent with the findings made by the referee, and in some cases misinterpreted or mischaracterized the evidence which the referee had given. So there was a level of frustration which I'll come back to a bit later on. Now, the first issue was whether the products were of acceptable quality, and the judge looked at the defects with the vehicles and concluded that no reasonable consumer acquiring any of these vehicles would have believed that it was acceptable. Effectively, if a vehicle in Australia, or really any country in the world, can't drive a vehicle over 100 kilometres an hour without it suffering major defects, then the product could not be considered acceptable quality. And he reiterated that view at paragraph 178. A reasonable consumer would not regard as acceptably fit for all purposes a vehicle that transports a passenger from A to B, but in doing so has a propensity to exhibit the defect consequences. So the foul smelling emissions, the smoke, but also other issues which were relevant. For example, there would be, as I said earlier, defect or warning lights coming up on the onboard computer. The car could also go into limp mode, thus losing considerable amount of speed. And there was also a reference to the fact that the consumers have had to suffer a lot of insults from other motorists because of the car's smelly emissions and smoke. And so that was a factor that was relevant. The ownership of these cars resulted in the owners of the vehicles being subjected to quite a lot of abuse from other motorists. And the judge concluded that in the light of all the evidence that he considered, the contention by Toyota that the core defect was non-defective was simply unsubstantiated. And I like the comment there, made in the teeth of the evidence. So they're making submissions to the court which simply have no evidentiary basis, but further contradict the agreed evidence that has been filed in the case, which is a very odd way of running litigation in my view. The second question was whether the conduct for Toyota had been misleading and deceptive. And clearly, when they're selling vehicles to consumers through dealers, Toyota salespeople and dealer salespeople are making representations explicitly that it's a good car, that it works effectively, doesn't suffer from any defects, good quality, reliable, durable, does not have a propensity to fail. So it's making these representations to consumers, and accordingly, these representations were considered to be misleading and deceptive. Clearly, when a vehicle has a propensity to fail and was unable to complete the relevant regeneration cycle with sufficient regularity to prevent the DPF from becoming completely blocked, there was a misleading representation being made. Also, there was a claim made by Toyota that it was a future representation, and for some reason they had reasonable grounds for making this future representation, and that didn't stand up in the face of the evidence as well, because it's clear that Toyota was aware of the problems with the vehicle for quite a long period of time, had sought to execute some fixes to the product, the first one of which was unsuccessful, the second one in 2020 which was successful, but there's an evidentiary burden which Toyota has to prove that it has reasonable grounds for making future representation, and the judge concluded that they'd failed to meet that evidentiary burden. Quite apart from that, it just seemed to me that there was no way they could claim they had reasonable grounds for making the representation for any vehicle sold after they became aware of the problems. Now, the other part of the case was whether Toyota had engaged in misleading deceptive conduct by omission. And as you can see there, the judge is concluding that Toyota continued to make representations to the consumers and was not pointing out the obvious defect with the vehicle. So effectively, if you're not telling the consumer something you know about, that's misleading by omission. So omission cases rarely are successful. So this is an example of an omission case that has been accepted by the court. And as you can see at the end there, the judge concludes that when there was a reasonable expectation that the vehicles were defective and would not operate in a suitable manner for the Australian market, that factor would have been pointed out to the various consumers, and it wasn't pointed out. Now, one issue that's really interesting about this case is the level of criticism that the judge had for the parties, but primarily for the Toyota party. And as you can see there in the beginning of the case, he says that one would have expected that this would be a very straightforward case, given everything that has been agreed to the referee and agreed statement of facts. But unfortunately, it hasn't worked out that way. He's not only critical of Toyota, he describes the relevant provisions of the Australian consumer law as being lamentably drafted. And also, he just identifies some of the problems inherent in large class actions. But the primary area of concern that he had was the actions of Toyota in maintaining issues which really should have been conceded or agreed. But actually, they were conceded or agreed in the agreed statement of fact and then reopened at the trial. And then he says again at paragraph 57 that it's highly regrettable that despite the sensible approach to engaging in the reference process and agreeing on the adoption of referee's report, so the way the litigation had been conducted up until the trial had been very sensible, retaining a referee, looking at the conclusions, accepting those conclusions, Toyota decided to just re-agitate all of those issues. And as you see there, he believes that Toyota's approach to litigation was devoid of merit and contrary to the whole purpose of seeking to facilitate efficient class actions. So that's a big concern why Toyota would participate in a process through a large part of the preliminary stages, and then when it gets to trial, try and undermine all the work that's been done before. And I think that's going to result in a very large costs judgment against Toyota down the track. Now, the issue that's very important here is how damages are to be calculated. There's a real big part of the judgment is dedicated to exploring these issues and trying to work through the best way to do this. And it's not the most riveting reading, I must admit, but I guess I'll try and summarize what happened here to avoid you having to read all that. The plaintiff sought two types of damages under 272 of the ACL. Firstly, damages for the reduction in value of the vehicle. So effectively saying that the vehicle had this inherent defect when it was sold for a particular amount of money. How much was it less valuable to the consumer than the price they paid? So there's a lot of talk about the way to argue that. Obviously, the two parties submitted different arguments as to what it should be. The plaintiffs were arguing it should be a 25% reduction, and the judge had to analyse a lot of evidence to work out what he thought it should be. The second thing is looking at the reasonable foreseeable loss or damage suffered by the failure to comply with 54, and this raised lots of issues about excess taxes, so GST, stamp duty, financing costs for people who bought the vehicle under finance, excess fuel costs. There was an argument that the defect had resulted in high fuel consumption, and then other costs associated with getting the car serviced. So, for example, lost income from taking time off work. Now, the judge went through a lot of evidence there and came to the conclusion that the net reduction to the vehicles was 17.5%. So that meant that every vehicle was ascribed a loss of value of 17.5% off the market value of the product when it was sold. And this raised a lot of complications about accessories and various things. So looking at basically the price that the person paid and then assessing 17.5% less, and that was damages payable using the market value as the starting point. The other costs that were sought by the plaintiffs included taxes, lost income, excess fuel consumption, and the plaintiffs were successful in some of these areas. There was a view that various taxes like GST and stamp duty costs and also financing costs for people who bought the vehicles on the finance were actually recoverable. Lost income from having to take your vehicle to the service centre numerous times was also recoverable, and the excess fuel consumption was not recoverable, only because the evidence didn't sort of get over the threshold of satisfying the judge that there'd been a significant issue there. So the plaintiffs had a mixed level of success in relation to these further costs. So I guess the final issue, what does it all mean? And there was an assessment made in an ABC article that the total damages per vehicle would be $7,000 at least, and they extrapolated $7,000 by 264,000 cars and claimed that there'd be losses in excess of $2 billion that Toyota would have to pay out to the class. The maths didn't seem right there. I think if you multiply those two numbers together, you get 1.8 billion. But I guess the issue that maybe the ABC factored into their calculation was these additional costs that will be recoverable by consumers in relation to lost income and all the rest of it. So that's going to be a process. Obviously, the 17.5% reduction can be applied across the board to the whole class. But when individuals are seeking additional losses for those reasonable foreseeable losses, such as lost income, stamp duty, financing costs, stuff like that, there probably have to be a further referee going through each claim, working what everything is likely to cost. So I think the estimate by the ABC that it's going to be over $2 billion potentially is accurate. Now, I think the interesting thing here is whether Toyota seek to appeal this case. Seems to me they've got very little opportunity to do that, given the level of agreement that was reached, the referee report, and the agreed statement of facts. So it just seems to me that the evidence was uncontroversial until the trial, and then there was an attempt to sort of re-argue those points. So I can't see that there's any real legal point to challenge. The only issue that might be worth going on appeal is the assessment by the judge of a 17.5 reduction in the value of the vehicles. That might be something worth arguing is either, well, it's too high. I don't think there'd be much of an argument that there shouldn't be any damages paid for that particular issue. The final issue is the approach which the firm used to this litigation, and I simply can't understand it. How is it that you can agree so much in the lead up to a case in terms of an agreed referee, accepting the report from the referee, creating a range of agreed statement of facts, following with the court, and then going into a trial and re-arguing everything? It doesn't seem appropriate to me. It wasn't likely to succeed, and as I said earlier, it's likely to result in a very large cost payment by Toyota to the plaintiff's lawyers, because they've unnecessarily expanded the time and cost associated with this case. So I guess it's a questionable approach. It's curious to me why you do it. If you're going to fight a case, you fight it hard from the word go. It's strange to sort of compromise and then decide to wage all-out war. So I think it was an interesting case. There's a bit more to happen here, whether Toyota appeals and also what the final damages amount is. But I think it is a good testament to the way class actions can be effective in helping a lot of consumers. I was somewhat surprised that maybe the ACCC hadn't got involved in this case, mainly because it seemed to be a serious defect. It raised a lot of interesting issues under the Australian consumer law, and there was a great deal of detriment. But ultimately, it doesn't really matter because the plaintiffs have been successful in winning their case. So that's all I had. Apologies for this croaky voice. I've got a bit of a cold at the moment. But if you've got any questions about this presentation, feel free to give me a call or drop me an email. Bye-bye.